Hello, everybody. Welcome to WDMD 100, Lesson 9. Say hello to the cat. Go away, kitty. So last class we talked about copyright, and we talked about some of the implications of tattoos. Remember, there is a discussion, actually there's 3 discussions on D2L that I want you guys to participate in. Make sure you post at least something, your opinion about each copyright concept at least once. And you can certainly, go amongst each other and refute each other's answers or make it into a debate, really. And so yeah, post in D2L. That's due next week, Tuesday. And I see that a bunch of you have already posted, so that's great. And thanks for the awesome opinion so far. Everything looks really good. All right, so let's jump into the slides. We're going to go ahead with a little bit more in copyright. Yep, the reminder to comment on D2L. Okay, so let's talk a little bit about appropriation art. We touched a little bit on Jeff Koons and his copyright, the copying of, the puppies in a row. He took somebody's photograph and made it into a sculpture and got in trouble for that. Appropriation art is the use of pre-existing objects or images with little or no transformation applied to them. It doesn't necessarily mean copying someone else, though sometimes it does. And for people like Jeff Koons or Shepard Fairey, it's definitely something that they are in the public eye about more often than not, it seems, because they're constantly stealing other people's work. But it doesn't really mean that you're copying someone else, even though sometimes it does. Take Picasso, for example. This is a piece of art that he created using different newspaper scraps, sketches. There's some glass in there or something. So he's taken pieces of other already created things and putting them into his art. And that does apply to the definition of this, where it's the use of pre-existing objects or images with little or no transformation. And that's exactly what he did. Andy Warhol is another famous example of this. He took a Campbell's condensed tomato soup can and made it into a picture. And the reason why this is okay is because nobody is going to confuse the association with Campbell's and, a painting. They're not really competing. It's kind of like, if you took a picture of Campbell's and you had somebody, barfing it up, Campbell's might try to sue you for some sort of defamation or something of their image. But in this case, it's okay. And, even though it's been contested, it's been found to be totally fine. So it's kind of a fuzzy line when it comes to appropriation art. You can get in trouble for things like what Jeff Koons did in the lower portion of this picture, where he made this sculpture out of somebody's photograph. Or you cannot get in trouble for things like the picture above, where he took the feet from the image, from the advertising image, and reused them and didn't get in trouble, even though they tried. So it's really a fuzzy line. There is no definite, yes, this is going to get you in trouble, or no, it's not, as far as appropriation art goes. Remember the guy who used Barbie as well in his art, he was also fine. Coincidentally, Jeff Koons tried to sue other people for copying his art. Kind of funny, the pot calling the kettle black in a way. He tried suing a bookstore who made some bookends out of, they made some bookends. I think they were out of resin. I'm not sure. But they were the same sort of sculpture as this balloon dog. So the bookends were just basic balloon dog bookends. And even though that's a transformation of medium, the defense for the gallery, I think it was a San Francisco gallery bookstore, The defense said, as virtually any clown can attest, nobody owns the idea of making a balloon dog, and the shape created by twisting a balloon into a dog-like form is part of the public domain. So, remember when we talked about copyright and the concept of having an idea copyrighted it's not something you can copyright. This is one of those things where these balloon dogs have been created in shape and form for years by clowns. And so it's not really any original idea of Koontz's or of the bookstore, and they were both able to use it. Jeff Koons actually dropped his suit in this case. Here's another one that I mentioned before, Shepard Fairey. For some reason, I keep wanting to call him Stephen Fairey, but Shepard Fairey is a graphic designer, digital artist who is most famous for the Obama Hope poster, which he was in some trouble for. After the Obama Hope poster came out, it was found that he had taken that image of Obama he lifted it from an Associated Press photographer who had taken a photo of Barack Obama when he was a senator. And Stephen Fairey denied that he had used the photo, and he actually ended up in the process of the litigation, destroyed some documents and tried to make it look like he used somebody else's photo, like one that's okay to use. And in that case, he was, I think, found guilty of like contempt of court or something, and ended up serving more of a sentence. I think he got probation, a couple years probation and some community service, but he ended up getting more in trouble for actually trying to obscure the fact that he stole someone's image than actually the fact that he did steal someone's image. So it's kind of sad that in that case that, the original photographer, he didn't get more out of it. But the original photographer, as I understand it, did get, or actually the Associated Press, the original photographer didn't really mind that he used it, from what I understand, but the Associated Press was pretty mad. So I believe they settled and for an unknown sum. In another case where you see this picture here, this is actually a breast cancer survivor named Jessica. A friend of mine actually took a portrait of her, and you can see this story here. I'll just kind of give you a quick overview of it. A friend of mine took this picture of this girl for a charity event. Her name's Jessica, and she's a breast cancer survivor. And Shepard Fairey saw it, and he wanted to use it in one of his digital paintings for another like a breast cancer fundraiser. So he called her up, and she gave him permission to use it under the conditions that she be able to photograph him with the final artwork in his studio, and that her name is credited wherever it is used. So he said, okay, and after a while, she never heard from him again, and then started seeing this image popping up in galleries across the world. And none of the galleries had credited her at all. So she fought it, and with a lawyer or whatever, and I'm not really sure what they settled on. She doesn't disclose, but she actually ended up winning in the fact that future versions of it, they ended up putting her name on the image. And it was so interesting because Shepard Fairey never credits people, that other people online actually took notice to the fact that there was a credit on the image and was like, how did this happen? Because it's so out of character for him. So she won in that sense, not necessarily because, he didn't follow through with his original plan or promise, but she did get her name credited on any future versions of the image. Now let's talk about this guy, Wim Delvoye. He's actually from the Netherlands, I believe, or maybe where is he from? Belgium, I think. He's from Belgium. He is most known for creating a machine that poops. And yes, it's meant to be fed Belgian delicacies during the day, a few times during the day, and then it actually creates poop. If you want to see a video of it, I gave you the link. I'm not going to show it here in class, but it is kind of interesting. He's also known for tattoos on pigs. And this goes along with our tattoo discussion on whether or not it is okay to tattoo characters on people. What about tattoos on pigs? Well, take note of his signature here. What does that look like? He's deliberately copying Walt Disney in his signature, which I find kind of funny. It's the exact same font. He is known for tattooing. He tattoos Disney characters on pigs. He tattoos you'll see down in the lower right, the Louis Vuitton trademark image on pigs. And what he does is he either sells the pigs live to art collectors so they can raise them, do whatever they want with them, or he raises them on his farm in China and until they grow old and die. They are pampered. So even though a lot of animal rights activists are very against him tattooing pigs, because he actually tattoos them when they're piglets and lets them grow, he raises the pigs until they're old, and then when they die, an art collector that has purchased the pig can have the hide removed and tanned and hung on their wall. So kind of a controversial subject. It's not really appropriation art. It's more of a art to provoke people's emotions. But he got in trouble with Louis Vuitton. Louis Vuitton was trying to sue him for, of course, using their trademark on his pigs. And Louis Vuitton actually followed him to a lot of different countries that he was using these pigs as gallery displays. And they weren't able to sue him primarily because he actually moved his pigs. He was in like Switzerland, and I think Swiss law allowed them to sue him. So he moved his pigs to China where they couldn't sue him. So he was actually going to a different country to evade copyright infringement or trademark infringement as well. And even though there have been some countries who won't display his gallery, his pig art, because of that fact, because it's copyright infringement or because it's inhumane in their opinions, he gets by it by going to different countries. If he'd have done this in the US, animal rights activists probably would have skinned him alive, or Louis Vuitton themselves would have sued him. Who knows if they would have won, right? But they certainly could have tried. So what if somebody steals your art online? This is an interesting one. I'm going to show you a screenshot here. This is a website that looks eerily similar. Take a look at it. Looks eerily similar to my own website. So one day I was looking at my analytics for my website, which tells me, who visits my site, what Google searches they did to get there, or what websites they were referred from. So if Google is linking to my site, or if another photography vendor or something is linking to my website, I can see where the traffic comes from. Well, one day I saw traffic coming from this girl's website. It was jenniferloganathan.com or something. And I thought it was very odd to be getting, a fair amount of traffic from that website visiting mine. And it turned out that when I looked at the site, this is what I saw. She had been stealing all of the content or the design content from my site. So what did I do? Well, first of all, I made sure my website materials were registered with US copyright, and they already had been. I knew when I designed the site that there was potential for it to be lifted, and I wanted to protect myself against that. I was able to prove that my website was online before hers. But remember, in order to collect damages, I needed to prove that someone had access to my site. How? there wasn't really any way for me at that point that I knew of, to prove that she had seen my website in the past. So what I did was I called her after all her contact info was on her website, and she denied everything. She told me she had never seen my website before. She told me that that it was her web designer that was to blame. She told me that she, could prove that it was their content to begin with by producing the Photoshop files that were used to create it. And I thought, well, anyone can produce Photoshop files just by copying them by looking at another one. So that doesn't really prove anything. But I was able to prove that my website was online first with her by using archive.org. And I'll show you what that is here. So I was like, look, my website is much older in that design than yours. So archive.org has this thing called the Wayback Machine. And what you can do is you can look up what websites looked like in the past. It's actually quite fun. And you can see different points at which it changed. This one's been around for a while. This is February here. So hey, there's what my website looked like in February of this year. Let's go back here. Here's what it looked like in 2012. This design is quite old as far as web terms go. 2011. Oh, and this one is an old design that they don't quite have all of the images and stuff archived. So you can kind of tell what an old website looked like in the past. And I was able to prove that my site had been around a lot longer than she had seen. She was claiming hers was around. So what else? So let's just quick look at, you can actually see this is an interesting one, a really old version of Google. You can look up any website that's on the internet on this Wayback Machine. It's kind of neat to see. Here's what Google looked like. I think this is probably 1996. Way back here. This is what Google looks like today. Site's kind of slow. Here's what it looked like ages ago in 2000. So they had an About Google, they had a Jobs at Google. You can actually click these links too, and if they have it archived, it'll go there. So it basically looked like this. There wasn't much to Google at that time. So kind of neat. All right, so when she blamed her web designer, I thought, well, I could try to sue her web designer. I could try to sue her if I wanted to, because all of the people involved are liable, if you recall. Oops, getting a phone call. Okay, so who is her web designer? Well, it happened to be some guy in India. So that complicates things much, much more, because India does not have the same copyright rules that we have. So I didn't really think I could effectively sue them and get any money out of it, especially since the fact when you take into consideration how much money is lost during the infringement. Well, really, I'm not losing any money when she's infringing on, even though she's probably gaining money because it is a pretty cool design, even though she slaughtered it. I wouldn't be losing any money under the fact that she was losing it. So really my options to sue were quite limited. and really get anything out of it. But remember all of the people, this is kind of a side note, remember all the people who are liable when a work is infringed upon. You have, if an employee infringes, their employer can be liable. Anyone who distributes the work can be liable from there. So you really have to check all your sources. Well, I assured her that even if her web developer was the one that lifted the design, the fact that she was still going to use it could be damaging to her, that I could sue her for that. But I ended up giving her the benefit of the doubt, thinking, all right, so maybe it wasn't your fault. Maybe it was your web developer, because there are some pretty shady web developers out there, and especially ones in India who are trying to make a quick buck. So I didn't sue her, but I did issue a DMCA takedown notice. And what that is, it's the Digital Millennium Copyright Act, or DMCA. It's kind of an addition to copyright that heightens the penalties for copyright infringement on the internet. The intent to induce, facilitate, or conceal infringement as well. It can result in statutory damages from $2,500 to $25,000. Now, when I talked about all the people who are liable when a work is infringed upon, the employee, the employer, people who distributed work, what about a web developer or a web host? So the company that is actually hosting her website, could they be held liable? Potentially. However, the internet service provider or web host, the DMCA rules, the DMCA laws created some safeguards, or an ISP safe haven, internet service provider safe harbor. So if the internet service provider, so in her case, I couldn't sue her internet service provider because they had no knowledge of her infringing on my copyright. So if they have no knowledge of the infringing behavior, if they have no financial benefit directly attributed to the infringing activity, like, for example, if an internet service provider knew that they were hosting a site hosting stuff like Napster. If you remember Napster, it's like a file sharing program that a lot of people use to pirate music and movies. They would actually be held liable because they know about what they're hosting, and they were probably, especially if their packages are set up in a way where the more bandwidth your website uses, the more you pay them, which is common with website hosts, then they're directly benefiting from you using all that file sharing bandwidth, and that disqualifies them from being considered under safe harbor. And then if they're given proper notice of infringing material being posted on their network, they have to respond expeditiously to remove or disable access to the material that is claimed to be infringing. So what that means is if they receive a DMC takedown notice like I sent, then they need to remove the infringed material or take down her website. So although the DMCA is part of US copyright law, a DMCA takedown notice does not require the content to be copyrighted in order to process the takedown. Meaning I could send a DMCA takedown notice without actually having registered my site with the copyright agency, which is great because I've actually had to do this before with other photographers who have directly stolen my photos and used them almost like they're their own, like they took the photo on their own website. And I've had to issue this notice for them as well. And some of those photos that I had to issue the notice for, I hadn't registered with the US Copyright Office yet. Or the internet service provider, needs to have the content taken down, acted upon by the website owner or ISP. So either the internet service provider has to take it down, or the owner, the person infringing has to take it down. And in fact, even if the website owner takes down the infringing content, I can still sue them. This does not mean that you can't sue them if they take it down. So what happens when you issue a DMCA takedown notice? You just basically write a letter. It needs to have a physical or electronic signature on it. You have to swear that you have the authority to represent the copyright owner under penalty of perjury, or swear that you are the copyright owner yourself. must be made in good faith belief that they stole the content, and it must identify the infringed works and the location of those works. So I sent them a letter signed that I own this website. It's been online for ages. Here's the archive.org link to where it, was launched in 2011 or 2010. And here's a new website that you just put on your servers by this girl, Jennifer Loganathan, and she's infringing on my site. And I'm not sure if it was her that took the site down or the internet service provider that took the site down, but it did go down, and it was down within 24 to 48 hours. And typically, DMCA takedown notices are very effective in getting content taken down. The burden is often on the copyright owners and representatives to identify the content, but the problem is that it can be put up again by the person who infringed. They could start a different website, or, after they host it with a new hosting provider, they could just launch it again. So every ISP must implement and adopt a policy to provide for the termination of repeat infringers. For example, eBay has a written policy about repeat infringers who sell pirated stuff on eBay, because eBay could become liable too if somebody is selling pirated stuff on there. And many dedicated piracy sites are actually hosted overseas outside of the reach of US law enforcement. So in such cases, a DMCA takedown notice is likely to be ignored, unfortunately. So what happened? The site came down, so that was successful. But then I actually one day was looking on Pinterest, and on Pinterest you can see, I'll actually show you an example of this. On Pinterest, it's kind of cool because you can see, let's see here. You can see who pinned things from your website. Just by going to a certain URL. So here, by going to pinterest.com/source and then the URL, I can see what was pinned by people from my website. Kind of neat. There's a lot on here. And I don't even know if I have the original thing that she pinned. It's probably going back quite far now. But I do have a screenshot of it. So I found out shortly after that she took the site down that I went on Pinterest and happened to look at what was pinned from my website. And here, 6 weeks prior to putting her website online, she had pinned images from my site. So when she told me that she had never seen my site before, she was a big fat liar. And I documented all of this just in case, and just in case she put the content back online. She could have waited, since it was a new website that she was building. She could have waited 6 months until I forgot about it and probably tried to put it back online, but she didn't. So I documented everything to make sure that I had screenshots of archive.org showing my page, her page, the fact that she had pinned photos. And if it ever comes up again with her that she's stolen my content, I can prove that she has seen it. And that was the last little bit that I needed. Remember on this past slide here where, I have to, in order to collect damages, I need to prove that someone had access to my site. Well, that right there proves that she had access to my site. So sometimes people stink. So how do you protect yourself if you have content on the internet? First of all, you should register your copyright. The only place that you should be registering your copyright in the United States is with copyright.gov. The government is the only legislation office that can do anything for you. There are ones, and let me see if I can switch here. There are other ones that try to get you to send in a copyright with them as well. And basically what they do is they take your work or a photo of your work and put it in a sealed envelope that's dated and notarized and shows that, you know, you created this piece of art or something on a certain date. And that's not copywriting. It might be able to help you prove that you created something before someone else, but it's not going to help you as far as copyright goes. You need to register your work with the government. I'll show you here. This is what the US government's copyright website currently looks like. It changes from time to time. Right here is where you register a copyright. It is not the most intuitive system. Remember we talked briefly about usability earlier in the semester. This is quite outdated and it takes a little bit to figure out, but there are manuals online and things to walk you through it. It costs $35 to register online, $45 if you mail it in. And if you're a photographer, you're trying to copyright something that has multiple things or multiple pieces of content, you can create a group registration as well. So it's really not all that expensive. Like I can take my photos from an entire wedding if I wanted to, and put them on a disc and send it to the US government for copywriting, and it cost me $35. And for some weddings where I feel like if I post images online and people might steal them, I do register them with the government. So let's see here. So that's an important step in protecting yourself. Why should you register? It is actually required before filing a claim for US authors on any copyright infringement. The remedies are limited to actual damages and no ability to recover attorney's fees if you register your work after infringement. So it's important that you register your work before. You know, in the case of my website design being stolen, I had registered my my work before the infringement happened. So I would be able to prove that, you know, she was, you know, that was my work, and I would be able to try to get attorney's fees and damages from her infringement. But if I had seen the infringement and then quick and gone and registered my website under the, you know, US government copyright, and then went back and tried to nail her for infringement, I wouldn't be able to get as much for damages. You know, with registration before infringement, you can seek damages from $750 to $30,000 and attorney fees. And statutory damages can be enhanced up to $150,000 if the infringement was willful. It happens, but it doesn't happen all that often. So watch out, like I said before, you watch out for things. There's copyrightprotection.com. I think there's a couple other ones. I don't think copyright.com is bad. I think that's an informational site. But copyrightprotection.com, and there's a lot of law firms out there that'll try to do this where they try to sell you a copyright, where they put your work in an envelope. It's not a proper copyright. There's also, if you're going to try to copyright things in other countries, the Worldwide Copyright Protection is a good resource. And we'll go to their website here. Let's see here. They have a bunch of different members, countries that will sort of honor copyright, and it has information on what is considered, you know, copyright, what's copyright infringement. Let's see here, country profiles. So you can select a country. Let's see here, let's look at Bhutan. That's a country that I'd love to visit someday. They have you can look at their national, they call it intellectual property, which is IP. So whatever your intellectual property is, they, whether it's a writing or art or music, they will go through all of the laws of each country. So in my case too, I actually didn't look up what the actual copyright work is in India, since it was a web developer that also aided in stealing my website design. But this would have been a good resource to start. So let's say you have work online and you have, text or art online, and you want to figure out, or you're trying to create something, and you actually find an image online that you want to use. And say you want to find the owner of the image. Say you want to put a picture of some forests in your research paper, and you'd like to give the owner credit. Well, how do you find that owner? Because a lot of times, like when I create photos in Photoshop, it's kind of cool because Photoshop will embed, Photoshop and Lightroom, which are image editing programs, they will embed the copyright information into the actual image file. But when you take that image file and upload it to certain sites, like if you're uploading it to Facebook, Twitter, stuff like that, the copyright will be stripped. For some reason, those online places just strip out all that metadata and the copyright information is gone. Facebook no longer does that. They actually keep the copyright now, which is awesome. But there are still a lot of places on the internet that do not. So how do you find that image if you want to track down its owner? There's a couple resources that you have online. You have TinEye, which is a reverse image search. So let me go. I'm going to take, let's see here. I'm just going to copy the image URL and put it in here because you can enter an image address. And I'm going to search it and see if anyone else has stolen this image or where it might be shown up online. And it looks like the only place it's found is on my own website. So that's great. Nobody has stolen it. So you can do that with just about any image. If you find it in Google Images or whatever, all you do is Google image search. Oops, I don't want my calendar. Oh boy. Let's see here, we'll go to images. And we'll just search for weddings because I like weddings. And say you find this image and you don't know where the source is, you can copy the image URL, go back to TinEye, paste the URL. The URL from Google Images actually links to the original source, and we'll see how many people. Oh, somebody who posted this image to their blog, it looks like, on dreamirishwedding.com. Actually, the image came from Getty Images, which is a stock photo agency. It's also used on Glogster, photographyfeed.com, taboosubjects.wordpress.com. So you can see all the places where this image was used. Oh, the authors deleted this site, probably because they were stealing images. Who knows? You can probably find this actually if you look at weddings that are on Getty. You look up some Getty images, you'll find them used on photographers' websites, like they took them themselves. It's sometimes, unfortunately, it's common where people are using stock photography because you can buy them right from Getty Images and then use them on their website, posing like they took it. Very unethical. Anyways, that is one way to search for an image. The other way is actually with Google image search itself. So you can actually search by image here by clicking the little image sign, the little camera. You can paste the URL, or you can actually upload an image. So I'll paste the same URL. We'll see what Google comes up with. And here they found people have pinned it on Pinterest. The Knot has used it. Here are some similar images. Different sites that have used it.
Hello.
And that is where it's used. So those are a couple ways that you can try to find out where the source of an image comes from, because it's not appropriate. And I've actually seen some people do this on blogs, where if they're crediting, they're using an image in their blog and they're trying to credit it to someone, they'll actually say photo by Google Images. That's not appropriate. Google Images is just a search engine. It's not really an actual source that you can credit. So be sure to try to track down the author or the maker of the image or even work. If it's text work, you can easily Google search that in Google text search. All right, moving on. So we're able to find the owner of an image online, or you can find a different image to use. So I think we're going to stop here. We're not going to go through, actually I think we do have time to go through Creative Commons. There are some sources online where we can look for different photos that are okay to use. And let me just quick go through them here. Creative Commons is a method of licensing. It's like copyright, but it's not a replacement for copyright. It kind of goes hand in hand with copyright. It's a nonprofit corporation dedicated to making it easier for people to share and build upon the work of others, consistent with the rules of copyright. So if you're trying to find, an image that you can legally use, you'll want to look at ones that are, not rights managed. So let's take a look here. There's actually a directory of different images that have Creative Commons licenses that tell you that you can use them in certain situations. So one of them is called Wikimedia Commons, and I'll bring that up here. And it has a database of 23 million, it looks like, freely usable media files to which anyone can contribute. So you can contribute photos and any digital assets to this as well. Here's a neat one. You could use that. A photo taken in India. That is the picture of the day. You can actually search this, and I'm going to search it for puppy. Here are photos of puppies that you could use. Very cute ones. So now this actually comes up with, oops, and I'm not going to go into here yet. It comes up with what the license actually is. So CC BY SA 3.0 is the version of Creative Commons license that it has. And I'll go through what the BY and the SA mean here in a minute. So I'll switch back here. So from creativecommons.org, this is the nonprofit that provides these licenses. We provide free licenses and other legal tools to mark creative work with the freedom the creator wants it to carry, so others can share, remix, use commercially, or any combination thereof. So what they do is they give everyone from individual creators to large companies and institutions just a simple, standardized way to grant some copyright permissions to their creative work, rather than it being a no, you can't use it, or yes, you can. There are different volume or different levels in between there. Creative Commons licenses enable people to easily change their copyright terms as well. So it can go from the default of, all or nothing, to some rights reserved. They're not an alternative to copyright. They actually work alongside it. And you can modify the copyright terms to best suit your needs. So here's what it looks like. We saw in the picture of the puppy, we saw a BYSA. Here's what the BY means. It means attribution. So if you are going to use this photo, you need to attribute it to the original author. They gave their name on that page. So it lets others distribute, remix, tweak, build upon the work, including commercially. Doesn't matter if it's commercial or not. So you can use it for a, profit, something that's going to make you profit. But you must credit the original creator. That's what the BY means. What about BYSA, which is what the actual image had? This lets others remix, tweak, build upon it as long as you're credited. And the SA portion means that you must license your new creation under identical terms. So if you create something using the image and this image is BYSA, then what you create also needs to be BYSA. It needs to still credit the original owner and any derivatives of this, because this one allows commercial use. Any derivatives of this designated work also need to be allowed for commercial use. Okay. How about attribution, no derivatives? So we've seen the BY before. That means that you need to credit the original author. The ND means no derivatives. You can redistribute it. You can redistribute it for commercial or non-commercial purposes, but you cannot change it. That means you cannot create a derivative of this work. It has to be unchanged and it needs to give credit. So BY means you need to give credit. ND means no derivatives. You can't change it, but you can still use it. How about attribution non-commercial? BYNC. So you have to attribute it to the original author, BY. And new works must also acknowledge you and be non-commercial. Derivative works don't have to be licensed on the same terms because remember, same terms is the SA form or SA portion of it. So SA is not designated in this one. Derivative works don't have to be licensed under the same terms, but they do need to acknowledge the original author and they cannot be used commercially. So non-commercial, attributed to the original author. How about attribution, non-commercial, share alike? Now we're starting to make things a little more complicated, right? You can combine any of these Creative Commons licensing terms. You can create, ones that are specific to what you want to do, really. So BY, of course, means you want to attribute it to the original author. You can drop that. You can drop the BY out of here, and then you don't have to attribute it to the original author. But in this case, this one has BY, so we're attributing it to the original author. Non-commercial, so we cannot use it in commercial means. And SA, which means, of course, same alike. Needs to have the same license as the original. And then any derivatives will have to be in non-commercial in nature as well, because they have to carry the same terms as this one. And similarly, this one is the most restrictive of the Creative Commons licenses, which allows redistribution. It's also called the free advertising license. So basically, you can use my work, but you have to credit me for it. You can't change it. You can't use it commercially. But it allows others to download your works and share them. You have to mention that the original author and link back to them, BY. You can't change them in any way, the ND, no derivatives. And you can't use them commercially, NC, the no commercial. So let's look at a couple of things on the Wikimedia Commons page. Here's the puppy. Oops, gotta switch the screens. Here is the puppy. There it is. Here's the puppy picture. So this was created by a guy named Huegos Olympicos. It's his own work, made in 2012, a golden retriever puppy, he titled it Peril. Creative Commons license says that you need to attribute the original author, and SA, remember SA is share alike. So you must license any new creations that you create with this under identical terms. You can create derivatives of it if you want. So I can turn this photo to black and white if I wanted to use it as a black and white photo. And then it also, it allows me to use it commercially because there is no NC on there, which means non-commercial. So I can use this one commercially because that's absent. Let's look at another picture of a puppy and see if we can find one that has different terms. How about this one? This one just has a BY. So all we have to do is attribute the original author. And it's nice because there's a view terms button on here too. So you are free to share the work, copy, distribute, transmit it, free to remix or adapt the work under the following conditions that you attribute it to the original author. Now this image actually came from Flickr, and I'll go to Flickr in a minute. I don't know how to get back. There we go. I want less details. Let's see if we can find another one here. This is another one, BYSA, share alike, attribute it. Another BYSA. See if we can find something else. See if we can find like World Trade Center photos. Those, oh. Also BYSA. Boy, I'm on a roll finding ones that are all the same. Oops. This one's also BYSA. Goodness, maybe we should move on to one of the other places where you can find photos. So other places that you can find photos that you can use are stock agency sites. So I'm going to go to one here called Fotalia. Now you pay for these images, but they are royalty free, which means you are able to use them in any manner you choose. Now what I was explaining before is that there are some photographers out there who will buy these photos and say, oh, this is a nice photo. I'm going to take this and I'm going to put it on my photography website and make it look like I took it. Because you can buy these photos and use them for that. And there are some terms and conditions against doing that, and that's very unethical as well. So using these images in that way, in that manner, is not recommended. But you can use this if you were to write an article about weddings in the Caribbean and you just wanted to use a stock photo for your article to illustrate your article. You can certainly purchase one of these and use it. You can use this as a background to a flyer if you were sending a flyer out or something. So just these are just memes, and these sites have thousands and thousands of different things that you can purchase all of these stock photos to use as illustrations or in graphic design. Fotalia is one of them. iStock photo is another one, although they were purchased by Getty Images, so Getty is the same, iStock by Getty. This one has gotten fairly expensive recently. They also have video clips, illustrations. You can buy this entire poster if you want. Kind of neat. I don't remember how much a credit costs, but it used to be $1 per design, $1 per credit. Now it's a little bit more than that. Another place that you can find photos to use is Flickr. Flickr will display, I can just browse. Let's see here. Let's look up Stevens Point. I can spell it, right? Surprised that something came up. Ta-da! There's people's photos of Stevens Point. The old Holiday Inn. And these have copyrights on them as well. So this one in particular is all rights reserved. This one is saying that the owner reserves all rights. You cannot do anything with this image other than currently looking at it on your screen. I'll go back and see if I can find one that isn't all rights reserved. This one's also all rights reserved. And I think you can do an advanced search that only search Creative Commons licensed content. Content that you can use commercially, photos. We'll look for Stevens Point in there. And there's a lot. So here's a photo that has some rights reserved. You can click on the information and it links you to Creative Commons and its license. This one is just a BY, so it's attribution. So you can share it, you can adapt it, you can use it commercially. You just have to attribute the image to the original owner. And his name is on the Flickr site itself, Matthew Fultz. One more place that you can look. And this one, DeviantArt. DeviantArt doesn't have, as a parent of a licensing listing on here, some of it. You have to assume with DeviantArt that it's all rights reserved unless it's listed otherwise. But DeviantArt is a good place for you to find content, and you can send messages to the owners as well. Even though you can just download this here, it doesn't mean you can use it unless they note that you can. Let's see here. Yeah, this one, I don't see it. So DeviantArt is another place to search. So those are some resources for you to find royalty-free images that are okay for you to use. And that is actually all that I have for today. So remember to comment on the discussions, make them into a discussion, and I will be back next week. Thanks, guys.